Welcome to the Supreme Court of the United Kingdom, where today we are hearing the second day of an appeal in proceedings brought by the Manchester Building Society against Grant Thornton, who are their former auditors. The issue in the appeal concerns the legal principles governing an award of damages. We're currently hearing submissions on behalf of Grant Thornton by Mr. Simon Salzedo, Queen's Counsel, and I'll invite Mr. Salzedo now to resume his submissions.
Thank you, my lord. My lords, my lady, yesterday afternoon, I was looking at the primary facts about the swaps, and I was taking a small diversion to show the court the schedule that my learned friend relied on at page 643, where the Society had applied the end date of swaps to the mortgages in order to achieve hedge effectiveness, and Grant Thornton had not corrected that. And I was submitting that there was an important distinction between Grant Thornton's advice on whether that approach was permissible within IAS 39, and on the other hand, the commercial merits of that approach, in relation to which Grant Thornton did not advise. Another example of a similar point is that earlier yesterday afternoon, in response to a question from my Lord Legate, my learned friend said that the basis of Grant Thornton's advice was that there would have been substitution in of new mortgages. Now, Ms. Savinclair put that very carefully and correctly, but it's important to understand that it's never been suggested that Grant Thornton gave any advice on whether there would be further mortgages. The accounting question was whether, if there was substitution of future mortgages, that could be accommodated as part of the hedge accounting process. Grant Thornton got that wrong, but Grant Thornton was never advising that such mortgages would exist or what fixed rates might be available to the Building Society decades in the future. Those were assumptions which my learned friend says the Society made, but she's never suggested any case that Grant Thornton was advising in relation to that assumption. Going back to the primary findings of the judge also made findings that the board understood that the rationale for the over-hedging in which it was engaging was to make a bet on long-term interest rates, in the sense that it was taking a view on what long-term interest rates would be that it understood was different from the view taken by the financial markets as a whole. And so going back to the judgment, if I may, in the key documents tab 8 at page 154, paragraph 84, the judge records that Mr. G, who was the finance director at the time and who gave evidence, accepted that the rationale for taking 50-year swaps instead of 20-year swaps was explained by Mr. Cowie, the chief executive, to the board of the claimant on 16 January 2007 and 25 January 2007. In essence, the reasoning was that using a discounted cash flow analysis, it was cheaper to take a 50-year swap than a 20-year swap. This was further explained by Mr. Walker in a note to the board dated 12th of March 2007, to which reference has already been made. That's a paragraph 76, which I showed you yesterday. It was judged, assuming a discount rate of 5.25%, that the taking of a 50-year swap was likely to be beneficial to the claimant because, looking at historical data concerning interest rates since January 1975, LIBOR was unlikely to fall to the break-even levels calculated by the model. And Mr. G agreed that this meant taking a different view from the market as to where LIBOR would be in 50 years' time. Now, my lords, the note from Mr. Walker, I pointed out yesterday, it was referred to here and also at paragraph 76. Just for your notes, really, it's in the bundle at page 616. It appends some calculations which are not easy to follow without a guide. My lords, I'm not planning to take time on that simply because of time, but if any member of the court is particularly keen to understand how those calculations work, I will explain if asked. And on this subject, if we also go to page 189 in the judgment, paragraph 239, where the judge is dealing with contributory fault, discusses the allegation that we were making, which the judge upheld, that in deciding to purchase 50-year swaps rather than 20-year swaps, the society was contributory negligent. And if we look, he introduces the question at page 189. If we go over to page 190 in the same paragraph, the judge says he does consider that the claimant was negligent in deciding to buy 50-year swaps. He's reached that conclusion for two reasons. First, the duration of the swaps greatly exceeded the duration of the lifetime mortgages. That meant the claimant would have to have been able to replace or substitute redeemed mortgages with new mortgages. There is no evidence that any thought was given to the question whether that was likely to be possible decades ahead of 2006. So still less, I would say, was there any suggestion, let alone evidence, that Grant Thornton had any role in that. Second, Mr. Cowie's memorandum to the board did not suggest that the claimant could be confident it will be able to replace redeemed mortgages. Rather, he assumed, with support from historical rates, that if interest rates remained at a certain level, it would in fact be cheaper to purchase 50-year swaps rather than 20-year swaps, even if there were no substitute mortgages. So that was actually the basis on which they did it. It wasn't the assumption about substitute mortgages. It was a calculation that if they were right about the movement of interest rates over the next 50 years, then they would find that they saved money or made money by buying the longer swaps. And it was actually explicitly on the basis that there were no more mortgages in the calculations that are attached to Mr. Walker's memo. My lords, my lady, the overhedging by length was highly significant in terms. I'm sorry, my Lord Leggett has a question.
What the passage that you've just taken us to shows, doesn't it, Mr. Salcedo, is that in this case, this aspect was dealt with perfectly well by the ordinary principles of contributory negligence. It's not like the South Australia case where the problem was that the fall in the market wasn't anyone's fault. So you couldn't apportion the loss justly by the rules of contributory negligence. But I can see why you can't in this case, and the way the judge did by deciding that it was 50% each way.
That one aspect, my lord, can be dealt with by contributory fault. The difficulty is that there were many other reasons, as I'm about to show you, why this business was disastrous for the society, many of which were nobody's fault. The unexpected effects of the financial crisis being in a way the obvious one. And one of those effects is that it was that the bet on overhedging went wrong. But there were other effects as well, which I'm about to show you, which we've never suggested were anybody was at fault for. And that's why there's essentially a gap between matters that can be dealt with by contributory fault and matters which are simply the commercial risks which a claimant may perfectly reasonably have decided to take. And this case, it involves elements of that as well. When I come to the law, of course, I'll be showing you and submitting that the law has decided that that's the way to deal with indivisible heads of loss is by the scope of duty principle. And it's too late to change that. But in any event, my lord, the rationale is that contributory fault does not cover the whole ground. There are risks which are the fault of the claimant, risks that are the fault of the defendant, and many risks that are no fault of anybody, especially in commercial transactions. So, my lords, my lady, the overhedging by length was highly significant in terms of the value difference that there ended up being between the swaps and the mortgages. I may not need to labour that point as it's fairly obvious, but the judge's findings on it are at pages 192 to 193, paragraphs 252 to 253, where the judge, you may recall from the documents we complain about this, permitted Ms. Savinclair in reply at the end of the trial to resile from the common ground that the overhedge was actually the main reason why they suffered loss, but nevertheless held at paragraph 253 that the overhedge contributed significantly more than 22% of the losses when closing out the swaps. That's what he finds at 253. So it was significant. My lords, my lady, there was also an element of overhedging in a different sense. There was overhedging by a higher nominal value on the swaps than the nominal value of the mortgages. The judge discusses this at paragraphs 87 to 90 at pages 154 to 155. And at paragraph 90, he holds that there was not serious overhedging, save for one period, but there was clearly some overhedging of this sort. For example, at paragraph 89, the judge accepted that there was overhedging of 10 million in a particular period. Perhaps more important in terms of the relevance of this, we know that there was overhedging by nominal in 2013 when the swaps came to be broken, because the notional amount of the UK swaps that the claim is for, paragraph 9 of the judgment, is 74.2 million, whereas the lifetime book was sold for 68.4 million, paragraph 162 of the judgment, which was a premium on the original lending plus rolled up interest. So we know that the UK books rolled up nominal value was less than 68.4, whereas the UK swaps were 74. So there's a difference. It's less significant, but it's another form of overhedge. In 2013, the claimant paid 32,682,000 odd to break the swaps. As I mentioned yesterday, the two were not separate amounts. They had to be disentangled on the basis of factual and expert evidence. We don't need to look at the detail of that. My Lord, Lord Burrows.
Very sorry for the delay. I'm sorry, I missed your reference. Very tedious intervention, but I just wanted the reference for the judgment indicating that the UK lifetime books were sold. You gave us a figure and a reference, and I'm afraid I missed it.
My lord, that's the kind of intervention counsel doesn't mind. I hope I got this right. Paragraph 120 on page 162.
And the figure was?
The figure was 68.4 million.
Thank you very much.
And I was just saying that we don't need to look at the detail of the disentanglement. It's simply the point that they were in together, but the judge considered that at paragraphs 203 to 211, pages 182 to 184 of the bundle, just to show you that they really were tangled up together. The mark-to-market component of the break costs was their fair value. The judge says that at paragraph 21 at page 137, and it represented the market's estimate of the present value of the net payments that would be made over the remaining life of the swap. And that's not controversial, it's the agreed facts, paragraph 9, page 5. And the other fact to which we draw attention is that the mark-to-market on the swaps had, as it happened, moved even further against the society by the time of the trial. And that's in the judgment at paragraph 197, at page 181. It's also in the agreed facts at paragraph 22. My lords, my lady, I come now to, I think I may have promised this yesterday, but I'm going to do it anyway, which is to deal with a question that my Lord Legate raised yesterday about the role of the accounts being wrong in this case. And a related point was raised by my Lord the President in relation to whether this case was similar or different to AssetCo. Now, I've already said, I think, that the society has never advanced its case on the basis that the board were misled about the commercial effect of their transactions. Equally, the society has never said that the board were acting improperly or even foolishly in a way that would have been reined in by shareholders if they'd read the corrected accounts. So in that sense, it's completely different to AssetCo, where the board was acting dishonestly, and if the accounts had been correct, they would have been reined in, whether by non-executives or by shareholders. Now, my lords, my lady, if that case had been made, it would have required the society to establish, as a matter of fact, when and how the board or the shareholders would have acted had those matters been corrected, and what loss would have been saved thereby. And there are 2 points to make about this. The first, as you've heard from Ms. Savinclair, the society's cases, it assumed it could undo the overhedging in the years ahead by writing new mortgages. The society's case, therefore, is that it knew that if interest rates went down, it would be making fair value losses because obviously the intended future mortgages would not yet exist. So there's no case that the board didn't know what it was doing at any stage. The second point that I make may explain why it is that the Society has never put its case this way. There are other possible explanations, but let me provide one. If we go back to a page that my learned friend took your lordships to yesterday, 955, it's an extract from the 2006 financial statements. And your lordships will recall being shown at the very foot of the page, the entries that relate to the swaps and the mortgages. And in the 2006 year, you can see, as Ms. Savinclair explained, that the swaps at that stage were in profit. So there was a gain on the swaps of 318,000. If Grant Thornton had correctly said that hedge accounting was not available, what that means is the gain of 318 stays in because the swap must be accounted for at fair value under international financial reporting standards, but the loss on hedged items attributable to hedge risk of 361,000 would have come out because that's the hedge accounting adjustment. So the 2006 accounts, if corrected, would not have alerted anybody to a problem. They would have simply shown a beneficial holding of derivatives. If we then go to page 958, which again, Ms. Savinclair took the court to yesterday, and again go to the bottom of the page, you've got the figures for, just looking on the group column, on the right, the second column of figures is 2007. That's a comparative. This is from the 2008 accounts. You can see there what was in the 2007 accounts. And in the 2007 accounts, the position is very similar to what I just showed you in the 2006 accounts. The swaps were in profit. The market's view of long-term interest rates had gone up rather than down. So the derivatives now showed a gain of 563,000, and the hedge accounting adjustment was negative 515,000. So again, if Grant Thornton had spotted the mistake in its audit of 2007 accounts, that would not have alerted anybody to a problem. It would have made everything look rosy in the garden. The only time anybody would have been alerted to a problem is when the 2008 accounts were signed. And as your lordships and your ladyship can see, at that stage, as a result of the financial crisis, suddenly the derivatives were out of the money by over 26 million. So if the hedge adjustment had come out, that would have shown a problem. The agreed chronology at page 20 records that Grant Thornton gave its opinion on these accounts on the 3rd of March 2009. So if there were any loss claimable on the basis that the business would have been broken up sometime after the 3rd of March 2009, by which time the swap position was already negative 26 million or more, that loss has never been claimed or estimated. Obviously, any such loss would be rather smaller than the loss that has been claimed in these proceedings. But whether that's the reason or not, the fact is it was not pleaded on that basis. No witness evidence was adduced as to reliance on this basis. There was no expert evidence about what the overall result would have been on this basis. There's nothing whatsoever in the judgment about this. There's no finding of contributory fault on this basis, and this point was never raised in the Court of Appeal. And that's why this is a completely different case from Asset Code, because the problem in this case, the buying of the swaps and the setting in and the market losses on the swaps did not arise after the date of any signed accounts that were signed by Grant Thornton. The next heading I want to address is the question of whether the business was viable or sustainable in the absence of the hedge accounting problem. And I'm going to do this in 6 subheadings. First, I'm going to identify the case to which I'm responding. Secondly, show you briefly how that case was run and collapsed at trial. Thirdly, identify the value gap between the swaps and the mortgages, which is at the heart of the claim. Fourth, identify the society's explanation for the gap and what's wrong with that. Fifth, identify the true explanations. And then sixth, I just want to show you 3 documents that evidence my submissions. 2 of them I've already mentioned because they're extracted in the judgment. And the third is one that my learned friends have introduced into the appeal as support for their case on this point. So first, to identify the case that I'm answering, your lordships look at the appellant's written case at page 33 of the bundle, at paragraph 23. Your lordships, I know we've obviously read this before, but if your lordships just remind yourselves of 23 through to the diagram at 25, those paragraphs and the diagram are at the heart of the society's appeal to this court. They're an essential part of the society's case that the loss was caused by terminating the swaps early and not by entering into them in the first place. Their case in this written document was that the business of the long-term swaps and mortgages together was viable and sustainable, it's the words they use throughout their written case, save for the unavailability of hedge accounting. No factual references are given in those paragraphs that support those statements. If my lords and my lady would then go to page 41 and look again at paragraphs 39 to 41, similar points are made. Paragraph 39 is vouched by paragraph 16 of the judgment. Paragraph 16 of the judgment merely describes the nature of the hedge accounting adjustment. It says nothing about viable and sustainable. For paragraph 40, a reference is given. This is not to any finding of the judge, but to one primary document, the Society's business plan for 2012 to 2015. That's the third document which I propose to show you under my sixth subheading. And paragraph 41, again, has no references at all. Now, orally, Ms. Savinclair did not give much prominence to the terms viable or sustainable, but her case was in substance the same. In answer to a question from my Lord Hodge, she confirmed that her case was the business model had to be dismantled because it was unsustainable once it was appreciated that hedge accounting could not be applied. It does appear to be the same case. That's page 120 of yesterday. In response to a question from my Lady Black, she said that her case was, in real terms, what was happening whilst the hedge relationship was in place was that the society's actual position was the net of that arrow diagram. That was page 30 yesterday. And she later said, there's no suggestion that the society was incurring losses up to 2013 by this model, business model. The society was carrying on very nicely, page 40. So, my Lords and Lady, I'm not taking any particular point on the words used by my learned friend. My point is that this argument in the written case remains at the heart of the society's appeal, despite the words sustainable and viable not being so much in favour orally. Now, looking again at the diagram at paragraph 25, page 34, it shows approximate LIBOR going out to savers and banks and coming in from the swap counterparties. And then it shows fixed legs coming in at 6.5% and going out at 4%, giving a margin of 2.5% on the nominal value of the mortgages. And that would, of course, make a business profitable, subject to administrative expenses, so long as one assumes that the society can continue to write or acquire new mortgages into the future at similar rates to match against the long-term swaps when old mortgages terminated. And this diagram, along with the allegation of a gross margin of 2.5%, was part of the society's application for permission to appeal. Well, I appreciate that my learned friend did make clear yesterday that the 2.5% was what she called indicative. Now, the 2.5% margin, the idea of a locked-in margin was examined in detail at trial. There was reams of expert evidence on the point. The judge did not accept the case. The society did not appeal on the basis that such a finding should have been made. As we set out in our written case, the Court of Appeal also rejected this argument, at paragraph 92 of its judgment, page 125, making the following points. The Court of Appeal's points were, first, there's no findings from the judge to support this case. Secondly, it assumes a perfect hedge. Thirdly, there was not a perfect hedge for the reasons given by the judge at paragraphs 76, 90 and 239. I've shown you those paragraphs and they cover overhedging by term of instrument and also overhedging by nominal value. But the point is still resurrected here, and it is at the centre of the appeal, so I have to deal with it head on. Can I start with two very short extracts from the pleadings? Page 519 of the bundle is an extract from the re-amended particular claim, and we're looking at a paragraph which is actually paragraph 94CB, which starts on the previous page, continues on to page 519, and what is pleaded there is that the society would not have closed out the swaps in 2013 or the lifetime business or incurred costs and expenses if Grant Thornton were correct. It could apply hedge accounting. So here is the society's case on the Samco counterfactual. The swaps in the UK lifetime mortgage business in combination were profitable at the time of the sales. They locked in a margin of 1.64% profit as set out in Hall 1. Mr. Hall was their accounting expert. So that was the case that they pleaded. While we're on this paragraph, can I just invite your attention to a sentence that I'm going to refer to later, which is the last sentence of this re-amended paragraph. At the very least, the society will contend that it lost a substantial chance of doing so and will ask the court to award it damages on a loss of chance basis. So this was the idea that, and that's not, sorry, I need to go back to the rest of it. That's not the locked-in margin. That's what became called the scenarios. So 3 lines up from what I've just read, the society's case is that the third witness statement of Mr. G and Hall 2 correctly describe what would have happened if Grant Thornton's advice had been correct, and that is the scenarios about the kind of other mortgages they think they might have been able to write in the many decades ahead. There were 3 sets of scenarios, and they say at the very least they lost a substantial chance. So there was a loss of chance case within the Samco counterfactual. That's for later. The point I'm on now is the locked-in margin was 1.64%. What we said to that in the pleading is at page 553, paragraph 57.3b, where we said, in response to the claim introduced by re-amendment that they locked in a margin, this is denied for the reasons given in the expert evidence of Mr. Smith. Further, Mr. Hall has abandoned his position that the mortgage business and swaps locked in a profit of 1.64%, and we refer to the joint memo, which I don't think is in these bundles. In any event, we will rely on the analysis of Mr. Smith that showed that it would have led to substantial losses. So that was all in dispute at the trial. My lords, my lady, at the trial, the society's expert did indeed accept that there was no positive locked-in margin. We've got the passages where he did that because there's no specific finding of the judge on it. At page 859, it's a passage from the transcript of day 11 at page 12. And if your lordships and your ladyship look at line 15 on that page, over to the next page at line 4, maybe I'll read it out, but I think you're accepting, perhaps we could just clarify, that the idea that a locked-in margin of a particular figure is the margin on this book for the future, that's not realistic. Well, as I said earlier, my view has developed on that. And I wouldn't describe it as locked in because the subsequent calculations that Mr. Smith and I have both prepared show that it varies. Can we just clarify, because I'd like to understand, are you accepting that the idea that a locked-in margin of a particular figure going into the future on this book is not a realistic idea? It says yes. And then if my lords, my lady would turn on to page 1861 of our bundle, that's now the same day 11, page 27 of the transcript. And at line 5, I ask 6.37, he, that's Mr. Smith, our expert, makes the point the margin was locked in. I think you accept that. Was that a question? Yes, the question was, I think you do accept that. I have accepted that, yes. Yes, you do accept that, but I don't think we need to spend more time on it. Then at 6.38, Mr. Smith understood the society was at that point contending that the locked-in margin should be considered at the date when the negligence was discovered around March. I think what you said earlier to my lord was that it should be considered I think you said the date of the sale of the books. Is that right? Well, the calculation was in my first report was using figures at that date. That isn't expressing a view as to the date at which it should be considered. I understand that's for legal argument. Okay, as a result of his understanding, if we go to the next page, you can see...
What page are you on? I'm afraid I missed the reference.
861, my lord.
Oh, 861, thank you. Right.
I'm so sorry, I don't know if I've...
No, it's my fault.
But 861, anyway, your lordship hasn't missed much because that bit I was going over quickly to get to the nub of it at line 23. Okay, as a result of his understanding, if we go to the next page, you can see that he then performed a calculation as at March 2013 based on all of your inputs into the margin issue. Are you familiar with that? Yes. And it showed a negative result at that time. Mr. Smith explains at the bottom of that page that the reason for that is primarily because of the fact that the swaps were bigger than the mortgages in March 2013. You see, that's what he says. You're familiar with that? Yes, that's what the arithmetic shows in that example. And you accept that the arithmetic is correct using your inputs at that date? Yes. So the society's expert accepted that there was no built-in margin. It just wasn't true. That's why there was no finding from the judge. That's why there was no appeal on facts against the judge for not making a finding. It's because it didn't exist. It was also inconsistent with the other facts that I'm about to show you. And so I'm about to talk to make submissions about the value gap. Now, I've shown the court yesterday the various heads of claim that were pursued at trial. And what it came to was the society claimed that when the business was closed down in March 2013, there was in net terms a large loss realised. And we might call that the value gap. And as I've submitted, the value gap is the essence of the overall claim that's been made against Grant Thornton in these proceedings. The society has always disavowed any case that the sales were made on a fire sale basis or that there was no available market in the relevant assets or anything like that. The society's claim that the business was sustainable if only it didn't have to be closed early, therefore cries out for explanation. On the facts that I'll show you, the true explanation is that the lifetime mortgage and swaps business went disastrously badly in the conditions that prevailed in the financial markets between 2008 and 2013. It was not viable in 2013 or any time after the financial crisis. And that was not just because of the contributory fault of the society in writing too long swaps. That made the problem worse, but it was also because of unexpected factors, commercial risks that simply came about, which meant this business did not work. As an illustration of the value gap itself, in our written case, we've set out the figures and the references for those figures for the Spanish book. We've done that at page 76, footnote 9. I'm just going there partly because the electronic bundle was amended. I think there was a new practice direction after the cases were filed, so some of the references don't tie in. So I'm just going to very quickly show your lordship, your lordships and your ladyship what we said there and give you a couple of the corrected references. So what we point out there is that so on page 76, the Spanish lifetime mortgage book was not sold. It remained in the hands of the society at the time of the trial. As far as we know, it still remains in the hands of the society. So any profits there are to be had from Spanish mortgages, it will have. They were found to be expected to generate profits valued at 2018 in the region of 2.46 million after expenses. That was a figure that was agreed between the experts on the basis of the present value of the Spanish mortgage book in 2018, including all the net cash flows up to the trial and the anticipated cash flows in the future when those mortgages were gradually redeemed. Against that, the society is claiming Spanish swap break costs incurred in 2013 of over £11 million. That's not a controversial figure. The reference to that page of the particulars of claim that we refer to is 510 in the electronic bundle. There was no dispute at the trial that further Spanish lifetime mortgages were never ever going to be written. It's not controversial, but we've set it out in the footnote with a reference to Mr. G's witness statement, which is why it's not in the judgment, because it was not controversial. And the electronic reference for that is 950. So we know that the Spanish business by 2013, in aggregate terms, was heavily loss-making. There were never going to be any more Spanish mortgages, and there was a large net loss position. Similar calculations could be done at more length and complexity for the UK business. The Society's claim that it did suffer net loss implies that such calculations would show the same thing, as at 2013, there was a substantial value gap between the positive value of the mortgages and the negative value of the swaps. Now, the Society has an explanation for the gap. In the two courts below, the Society did not acknowledge the existence of the value gap or offer any explanation for it. In this court, my learned friends have given their explanation in their written case at paragraph 48, and Ms. Sabanclair has repeated it to your lordships and your ladyship. The explanation is they had to break the swaps, but they were not able to keep generating income from the mortgages over the future period of the lives of the swap. And this point is said in their written document, in their written case, to be a crucial one. They say that at page 65, paragraph 87.2. It's a crucial point. And it's actually promoted even above that at page 68, paragraph 91.5, where this point is said to be the fundamental misstep in the Court of Appeal's reasoning. This explanation is, I'm afraid, nonsense on the facts of this case. It's one of the reasons why we say this is really an appeal on facts. There are three possible sets of relevant mortgages. There's the Spanish mortgages. Those have not been sold. Whatever income they're capable of generating, the Society is still getting. That's accepted in the written case of the Society, actually, on page 44, footnote 27. Secondly, there's the UK lifetime mortgages, which were sold in 2013. They were sold for their fair market value, and as I've shown you in my run through of the primary facts, the judge found at paragraph 216 that that fair market value was a price that represented the best available estimate in 2013 of the value of the future cash flows of that book. So the Society has received the 2013 present value of whatever cash flows its existing UK lifetime mortgage book would generate into the future. It's received them. That leaves only the future mortgages, which had not yet been written in 2013. But as at March 2013, it was crystal clear that no such mortgages were ever going to come into existence. And that fact seems to now be central to this appeal. So I have to deal with it head on, even though it's a factual contention on which the Society can point to no finding from the judge and no finding from the Court of Appeal in its support. So I propose to start with what we can find in the judgment on this issue, and then suggest the true explanations for the value gap based on the judgment. And then I'll just go to those three documents I've mentioned, two that are in the judgment anyway, and one that my learned friends rely on, the business plan. So on the question of whether more mortgages would have been written after 2013, the judge considered this at paragraphs 199 and 120 at page 181 of the bundle. And he's considering there the scenarios that were put forward in Mr. G's third witness statement, which I showed you a reference to in the pleading. So these are scenarios within the Samco counterfactual. What would have happened if hedge accounting could have been applied and the business just carried on? And you can see at paragraph 199 that Mr. G put forward two scenarios as to what might have happened in the future, which led to much expert comment and analysis and many pages of closing submissions, but he fairly recognised this was speculation, and that what would in fact happen would depend upon the attitude of the FCA and the PRA towards lifetime mortgages, capital position of the society, capital requirements imposed on the society, movements in interest rates, movements in the rate at which new mortgages could be written, house price inflation, risk appetite and profile. And then the judge says at 200, in this, he was entirely correct. Trying to predict what is likely to happen to all these things in the next 30 or more years is an impossible task. Possibilities may be suggested, but what is more likely than not to happen is a very different matter. Thus, it's necessary for the claimant to establish on the balance of probabilities that the sums paid in 2013 would not have been paid over the next 30 or more years. The claimant is, in my judgment, unable to do so. Indeed, the claimant did not address the uncertainties mentioned by Mr. G. Rather, the claimant concentrated on seeking to establish a case that its mortgage business was profitable and will continue to be so well into the future. But even if this could be established, the claimant could still not establish that it would not have continued to pay out the swaps for the remaining life of the swaps. I've therefore not addressed the many pages of closing submissions on the question of the alleged present and future profitability. So the judge held in the first line of 200 that Mr. G was correct to say that the scenarios were speculation. So he did not even find that. I'm sorry, I see my Lord Legate has a hand up. I hope it wasn't up for too long. I was looking down at the document.
No. Hi, Mr. Salcedo. Doesn't this paragraph actually go to the heart of this case and what the issue is, which, as I see it at the moment, is quite a narrow one? Because what the judge found was that it's impossible to say, basically, what would or would not have happened over the remaining 30 years of the swaps. So if the claimant had to prove on the balance of probabilities that it would have lost the sums paid out in 2013 in any event, it couldn't do so. But it equally follows that if you had to prove on the balance of probabilities that it would have lost them anyway, you couldn't do so. And so it comes down to whether the burden of proof was correctly placed on the claimant, as suggested it should be in the BPE case, or whether, as Ms. Savinclair has made it clear that she contends, that that is in fact erroneous and the result is reached.
My Lord, I see the attraction of that way of looking at it, but the final answer to it is one which I think was suggested by at least two of your lordships yesterday, namely that if there was a burden of proof, even if there was a burden of proof on the defendant on this, that was satisfied by the fact that the mark-to-market value of the swaps was the best estimate of future cash flows under the swaps. So
the judge rejected that argument. So if we were to accept it, we'd be reversing him on what was essentially a factual matter. He rejected that at the top of the page.
Well, he did, my Lord. He held that that was also, he held that what would happen was speculative and inconclusive. But the Court of Appeal overturned him on that, and we say rightly so. We say that
he said that it's one thing to say that the market is making a prediction, but courts don't operate just off the basis of what a market price is as to something happening 30 years into the future. And from the legal point of view, it couldn't be proved either way. That was his conclusion anyway. So we'd have to find that that wasn't one he could properly reach.
Well, my Lord, in my submission, it's not realistic to call that a finding of fact. I mean, that is his the primary fact is as to the nature of the mark-to-market value being the market's best assessment of what it thinks the payments over the future term of the swap will be. There's a liquid and well-known market in these vanilla swaps. The price is quoted on screens every minute of the day. This isn't just somebody's speculation. It's not like hearing an expert witness and saying, well, I don't think his reasons are good enough. So the primary facts are found by the judge. The Court of Appeal held, and we say they were absolutely right to, that the judge was simply wrong to say that you could not have any view about whether the swaps would really end up costing the society money over their term. And that if there is simply a burden of proof, if there's a burden of proof on us, then we discharged it by showing what the nature of that payment was. It must then surely shift, we would submit, an evidential burden at least to the defendant if they want to say that, again, either that that's not right, for example, by saying, well, actually, by the time of the trial, things had improved and we could see the market estimate in 2013 was wrong. They could have done that, but of course they couldn't, because on the facts it got worse. Or if they want to say, against the payments on the swaps, we'd have had more mortgages, but that's what they tried and failed to do. And I'm going to show you some more factual reasons why the judge was not going to find that. But without the society being able to respond evidentially to what we said, in my submission, the initial burden was plainly discharged by the undisputed fact as to the nature of the mark-to-market value of the swap.
Well, that's just a snapshot, though, and the rate fluctuates all the time, and we've got 30 years to go. And the mere fact that people, the best overall estimate of the market now as to what they're prepared to pay for a stream of income running 30 years into the future is X, doesn't show that a court can be satisfied on the balance of probability that that is more likely to be the outcome.
No, but the question for the court here is whether the loss on the swaps, which was the mark-to-market loss that had built up on them by the time they were broken in 2013, was a loss that would have been incurred in any event, even if the advice had been correct. And on that point, the evidence is perfectly good that that is a loss that would have been incurred in any event, because it is the assessment of a liquid and active market as to what those figures would be. It's an assessment which is built into the agreements of the swap. I'm about to show you that they had to pay collateral for the mark-to-market value as it changed. So it was built into the agreements that assessment was a relevant matter. And the Court of Appeal were quite right to say that in those circumstances, A, it is not a loss to pay fair value to be discharged from liabilities that you have taken on. And B, if you have to assess whether it was a loss or what would happen in the future, the best evidence is the evidence of the market price.
Well, on A, it's important to focus, isn't it, that the loss, in at least the way the case was put at trial, and I understand being put now, is that it was having to pay costs that wouldn't have been incurred because the swaps would never have been taken on had Grant Thornton not been negligent. So it's a bit of a red herring to be focusing on other ways of putting the loss, because that's the way it was analysed at the trial.
No, my lord, with respect, I don't accept that. The basic measure of loss was the existence of the swaps and the build-up of the negative mark-to-market. That was the basic loss. But the SAMCO measure is not the basic loss. The SAMCO measure is not a component of the basic loss. The SAMCO question is, would the same loss have been suffered into the future? So, my lord, I don't accept that I'm putting it in a different way to what was an issue at trial. My Lord Burrows, if my Lord Leggatt will permit.
No, thank you.
Sorry, I didn't realise that was still going. Can I just follow this through? Because what Lord Leggatt has just said seems to me a very important way of looking at this. As I understand it, the proposition being put forward is that the basic loss, as you've described it, that is the factually caused loss, is based on the fact that these swaps would not have been entered into but for the negligent auditing, and therefore the 32.7 million would not have been lost. Now, I'm not sure in the answer you just gave you are disputing that, because what I think you are then saying is that may well be true in relation to what you've described as the basic loss, but there's then a cutback of some kind. You're describing it as the SAMCO cap or counterfactual that we then have to apply. And it's in relation to that the question being raised is, can we sensibly apply a SAMCO cap which requires us to think about what the position would have been had the information been correct in a situation where this seems, according to the judge, and one might say intuitively, wholly speculative, even if the market value might give you a present snapshot. It may be regarded as not satisfying the balance of probabilities either way, whether claimant or defendant. Is that not an accurate way of looking at it?
My lord, it's a way that it can be looked at, but it's not the right way to look at it, because courts do not generally like to decide cases on the basis of a balance of a burden of proof that can't be discharged by anybody. And this is not a case. This is not one of those rare cases where the position is so uncertain and difficult that it has to be decided on that basis. And certainly, it would be quite unfair on defendants if that meant that the scope of duty principle simply ceased to apply in a case where it wasn't possible for anybody to say exactly what would have happened into the future. And it would be unreal in my submission to say that one was applying the scope of duty principle at all if one's response to this situation was to say that the 32 million negative on the market value of the swaps, representing the market's view of the future payments under that swap, should be treated as if it was zero, because nobody knows whether it was really 32 or 33 or 31. And my submission is that would not be an application of the scope of duty principle. That would be overriding the scope of duty principle, really for absolutely no good reason. And there might be cases where it's so speculative, in which case it would come down to a decision of law on where the burden of proof lie. But that's not this case in my submission.
And might it then be said that this is a case where the Samco principle ultimately doesn't help one way or the other, because it can't realistically be, the burden of proof can't be discharged by either party, and therefore you might say, well, it's not an appropriate tool for this sort of case. Is that a viable proposition?
My lord, as I understand it, it is Ms. Savinclair's proposition, but it's not one that I would call viable, because first of all, it's contrary to I'm going to go to the law, and I will submit that using the phrase tool as a kind of the derogatory phrase to mean that it's an optional matter is not the way Lord Sumption was actually using it in Hughes Holland at all. He was using the word tool to explain that the justification for the scope of duty principle is to award loss that's within the scope of duty, and the tool for doing it is to ask the counterfactual question. He's not saying that that the counterfactual question is optional and you can simply leave it out. And if you were, one would then have to find some other way of ensuring that the only losses awarded were those within the scope of duty, because this point, and this case illustrates it, does reflect a reality about the nature of the advice being given. Grant Thornton were not advising the society that it was a good idea to buy very long-term swaps to hedge their mortgage business. They really were not. They had nothing to do with that at all. All they were telling them was that if they did it, it would be all right to account for it in this particular way. And it is true that but-for causation is made out, because the society established that if it had not been able to use hedge accounting, it would have known it couldn't do this. But my lord, it would, in my submission, be unfair and a wrong principle to simply override scope of duty and put one back to a situation where all effectively but-for losses are awarded. My lord, Lord Legate.
In terms of fairness, isn't it a general principle of the law of damages that where there is serious uncertainty about a hypothetical situation that the court is asked to address, the inability to establish what would have happened, the risk that that won't be reasonably possible of ascertainment, should lie with the person who's created the problem in the first place?
No, not quite.
That is the principle that underlies the wasted expenditure rationale, for example, and you could see it in various other places in the law of damages.
With respect, my lord, I would submit your lordship puts that a little bit too high. There's the famous 18th century diamond case where because the defendant had stolen the diamond, he was fixed with the consequences of it being as big as it might have been. But that
Andre Delamere, yeah.
Yes, exactly, my lord. But that has been, I mean, that case has not been applied as widely as some have suggested that it might have been applied. And my submission is that the law on that now is that if the defendant has caused it to be, the evidence to not be available, then that might be something that entitles a court to make an inference. But in a general case where the court has to decide a hypothetical arising out of a defendant's breach of duty, the defendant is not shackled with some unusual inference against it or unusual burden of proof. The court will do its best, but it is still for the claimant to prove their loss. And the burden on the defendant is not made unmanageable simply on the basis, well, if it hadn't been for the defendant's wrong, there would be no hypothetical question.
Well, when it comes to law, sorry.
No, not at all. You pursue your point, Lord Leggett.
I was just going to say that when you do come to law, I'll be very interested to hear what you say about the wasted expenditure analogy that Ms. Sinclair drew.
Thank you, my lord.
The only point I was going to raise, Mr. Salcedo, it was in relation to Lord Leggett's first point, not the second one. It strikes me that it may be an incorrect approach to treat the building society, to treat the defendants as liable, and to look and then to start thinking about what damages are they liable for, and as it were, start with a figure generated by but for causation, and then start cutting it back by the application of various principles that operate as caps or tools, like as mitigation of damage does, or contributory negligence. I mean, there's nothing very new about Samco in that. I mean, classically, in Caparo, I think it is, Lord Bridge says that you don't have liability in the abstract. Liability is inherently linked to the damage for which you are liable, and that is generated by the nature of and extent of the duty that you have breached. And if you think about it in that way, which I think it's the approach that certainly Lord Sumption was taking in BPE, then Samco isn't a cap. It's simply focusing, or it's emphasizing the need to focus on the nature of the duty which was undertaken and broken and breached. And that, once you've identified the nature and extent of the duty, you're then in a position you're then able to identify the damage, which is a legal counterpart, which is a counterpart of the liability for breach of that particular duty. And so, if you're looking at it in that kind of a way, you're not going to find yourself in a situation where you already quantified the damages on a sort of preliminary basis, and then you're asking whether you cut them back on the basis of Samco and being unable to apply it because of a difficulty of the evidence, and consequently awarding the provisional figure that you first thought of. I rather think you would be looking at it more the way Lord Leggett was suggesting latterly, that if there's a problem about on the evidence in quantifying the damage, which is the consequence of your breach of duty, understood in a Samco way, then you adopt a realistic and indeed generous approach to the victim of a wrong.
Your lordship is absolutely right, and I adopt all of that. And it may be that I lost sight of it in trying to answer perhaps too directly Lord Legate's questions. But your Lordship is absolutely right. So the question for the scope of duty principle in this case, and as your Lordship points out, certainly Lord Hoffman in Samco and Lord Sumption in Hughes Holland saw it as a question about the scope of the duty as a preliminary rather than as some other limit on damages, although it was also described as a filter. But it is at the start of the inquiry. And so the ultimate question on this issue is, was it part of Grant Thornton's duty? Was it within the scope of their duty, as it's put, to take responsibility for the market gains and losses that may arise on selling lifetime mortgages and taking on long-term swaps to hedge them? And in my submission, when one realizes and remembers, as your Lordship has reminded at least me, that that's the question, one can see why the answer in this case must be no. Grant Thornton had no role in the commercialities of all this. Their only role was providing one piece of accounting advice, very specific accounting advice, which admittedly was a necessary factor, which is exactly the situation which engages the need to ask the scope of duty question. Because it's exactly in that situation that the scope of duty can't be said to be all the foreseeable losses.
Yes, just before I leave this point and hand over to Lord Sales, I think it's because Lord Sumption sees scope of duty as being at the heart of it, that he sees this as one of those issues where the onus of proof lies on the claimant rather than the defendant. But that would obviously be it wouldn't prejudice in any way the application of the principle that one saw in the Jewel case, for example, and indeed many other cases, that if the consequent, but obviously one can only quantify damages as precisely as the evidence allows, and if the evidential difficulty is a result of the wrong that was done by the defendant, then you adopt a generous approach in favour of the claimant to any evidential, to resolving the evidential problem.
Yes, no, I see that, my lord. And of course, I would say that in this case, the difficulty is not one that, because the difficulty is, as I would see it, even without starting with Samco, if you start with the question, is it what they were advising about? The answer is no. So the difficulty in assessing whether exactly that loss is the one that would be suffered is not something that is specially to do with the defendant's negligence. Did I gather Lord Sales?
Yes, Lord Sales.
Thank you. Yes, I think that I'm following what you're saying about the critical nature of the question as to what the scope of the duty is. And you say that the defendants weren't responsible for the market gains and losses which might arise from going down a particular route. But on my understanding at the moment, in a sense, the commercial gateway to the society being able to go down this particular commercial route and engage its business model was that the regulators were going to need to be satisfied as to the regulatory capital available for that. And that in itself turned critically on the availability of the hedge accounting, because the regulatory capital was going to be assessed in the light of the volatility that appeared from the accounts. And if there was no hedge accounting, that volatility would be great, and the regulatory capital required would be great and prohibitively expensive. Now, if one thinks of a case where the board is deciding whether to declare a dividend, which I think was the BTI case, and it's advised as to the account showing a particular true and fair view of the financial position of the company, and on the basis of that, they decide to pay a dividend. As I understand it, unless you challenge it, that would be a form of loss which would be recoverable by the company. And what I would be assisted by at some point is if you could explain why the current position is different from that, because the directors knew that the regulators would need to be satisfied by the accounts being prepared in a particular way in order to keep the regulatory capital requirements within bounds which the society could afford. And it was only because of Grant Thornton's approving the accounts in that form that that gateway, the regulatory capital gateway, was opened, allowing them then to embark on the commercial activity which they proceeded to do. So why is that not analogous to the situation where the directors need the accounts or have to be satisfied that the accounts show that a company is profitable before they declare a dividend?
My Lord, I wouldn't characterise or explain the facts in quite the way that your lordship puts them to me. I'm not sure if it's a difference of sort of view of the primary facts or just how one puts it. But let me, if I may, say how I would put it. My Lord, there was no commercial gateway. There was no. I think your lordship used the phrase to me, commercial gateway. There's certainly no commercial gateway. There was no suggestion that the regulator was going to look at the accounts in order to see whether this business was acceptable. The causal chain is not controversial and is in one sense straightforward. Because the swaps had to go on the balance sheet, and that was something that changed in 2005 when the society was required to report under IFRS instead of UK accounting principles. If you only did that, then the risk was that the swaps could go up and down with interest rates, and that would cause volatility on the balance sheet. And the society realized that it's not that the regulator wouldn't stand for volatility, it's that if the balance sheet went down too much, then the society would end up with less regulatory capital, which was measured from the balance sheet. And that would obviously cause it a problem because it was regulated and have to have a certain amount of capital. So it's not that, and the benefit of hedge accounting was it allowed you to put an adjustment on the mortgages, which would always go in the opposite direction to the changing value in the swaps. So it would reduce the risk that your balance sheet balance and therefore regulatory capital would reduce if the swaps went out of the money.
Yes. Well, can I just ask at that point in your explanation, why is that different from accounts showing that a company has retained profits out of which it can pay a dividend? In this case, it's true they didn't want to pay a dividend, but they did need to be sure that the accounts would show that there was sufficient capital to satisfy whatever the regulatory capital requirements of the regulators were going to be.
The reason it's different.
Sorry, just to finish the point. And if you don't have hedge accounting, the accounts would have shown volatility, which in turn would have required the regulator to demand higher regulatory capital, which is, in a sense, just taking away from the capital which the company has available for its activities. And it therefore would not have proceeded with those activities, just as if a company on a true understanding of its account realizes that it's not profitable, would not declare a dividend.
The reason that it's different is because in the dividend example, the accounts correspond to commercial reality. And it's not just, there's obviously the question of lawful dividends, and that's one thing. But the principle that a dividend is recoverable does not depend on the dividend being unlawful. The dividend is recoverable anyway if the accounts misled the directors into thinking they had enough money to pay it in a commercial sense. And so in that example, as in most normal audit negligence cases, if you like AssetCo, the allegation is that the auditor has misled the directors and or the shareholders into thinking that the company is better off than it is. and that in reliance on that, the company either continues to do the loss-making thing, or it spends money on a dividend that it would not otherwise have spent. This case is completely different because there's no allegation that anybody was misled as to the true financial position of the company. Everybody understood the actual commercial impact and financial impact of the swaps and the mortgages. The only thing that they didn't know was that they weren't actually entitled to recognise the additional profits on the mortgages in their accounts.
Can I just ask one last question and then I'll be quiet? I mean, you say that in an ordinary auditor's negligence case, the dividend type example, the company is led by the auditor's negligence to believe that it's better off than it is, and hence makes the payment of the dividend. And why isn't that true? I accept not in relation to the financial state of the company as to whether it can declare a dividend or not, but as to its capital position. So in this case, because of Grant Thornton's approval of the hedge accounting, the regulator says that regulatory capital has to be retained only at a particular level. And that frees up the company society to embark on a particular course of action, which it wouldn't have embarked on otherwise. If the true position was known, in a sense, might it not be said that the society would then have appreciated that it was less rich, if you like, in regulatory capital terms, and so wouldn't have been able to proceed down that course?
My Lord, I'm afraid my answer, I want to give the same answer, which suggests that it wasn't a very good answer, but the answer is that to say less rich in regulatory capital terms does elide two fundamentally different and critically different concepts.
Yes.
The society knew how rich it was. There's no allegation that it was misled about how much assets or liabilities it actually had. The only thing that Grant Thornton's advice was about was how it would be allowed to present those in the accounts and therefore to the regulator. And that's what makes this an unusual and different case. And if you say, well, how rich in regulatory terms, you are eliding those two quite different concepts. And it's vital to keep them separate if one is to understand the scope of a duty to give accounting advice about how a matter is to be presented. And that's why the judge in the end, after some wavering, as he says in the judgment, reached the conclusion that this was a case where the scope of duty did not include the commercial losses made by those transactions. It was because the advice was related only to presentation and was not related to the commercial impact, the financial impact of the transactions.
Yes, thank you very much.
My Lords, I may have to try and truncate some of what I was going to do, so I'll see how I go with that. Does your Lordship want to take a short break as we did yesterday?
I think that's experience has shown that most counsel, at any rate, appreciate having a short break in the morning. So we'll adjourn for 5 minutes. Thank you very much. Welcome to the Supreme Court, where we're hearing the appeal of Manchester Building Society, Grant Thornton. I'll invite Mr. Salcedo, Queen's Counsel, now to continue his submissions on behalf of Grant Thornton.
Thank you, my Lord. My Lords, my Lady, I was making some submissions before dealing with some of the questions about the question of why it all went so badly wrong. And I was pointing out that the judge refused to find that any new mortgages could have been issued. The Society's primary case at trial was that it would have issued long-term fixed rate mortgages, not lifetimes, but others, where the rate was fixed for 10 to 25 years. And as I've mentioned yesterday, I think it was, the Society already tried to do this in 2012 and found it very difficult. And that's paragraph 110 of the judgment. It was able to do very little. That's one of the reasons the judge wouldn't accept it could be done in the future. Their alternative case was that they would have issued new lifetime mortgages, but that was hardly likely because in 2013, the regulator had displayed intense concern about the lifetime mortgages and the society was responding by trying to reduce them. As again, I showed you briefly yesterday in the judgment by reference to paragraph 184. Even putting to one side whether a market existed or whether the regulator would have allowed them to do this, whether the mortgages would have been profitable is dependent on future borrowing costs, operational costs, and many other things. There were large quantities of factual evidence and expert evidence about this, and having reviewed all of that, the judge found that the society's case was speculative, as he said, 199 and 200. Now, we do submit that the Court of Appeal was right to hold that the lack of any finding by the judge against this background should be the end of the matter. But that's not accepted by my learned friends, so I need to go on to explain the true position. The real explanations for why there was a value gap in 2013, I'm going to suggest 6, and I'll start with the judgment and then come to the 3 documents. The first main explanation, the first explanation, was the overhedging in terms of length of the swaps, and I've shown you the judgment, paragraphs 192 to 193, about that. I've also shown you that there was overhedging in the nominal of swaps 154 to 155. The judge did not attribute any fault to the society for that, but it's a fact. Third reason is that because interest rates went lower, the society had to make regular net payments under the swaps. And those regular net payments were not matched by receipts from the mortgages because interest was rolled up to the end of the mortgages. So those regular net payments had to be financed, which had a cost. The society has never explained how much that cost was or how it was managed. And I'll give you some idea of their rates of finance shortly. Fourth, the decline of interest rates also meant that the mark-to-market value of the swaps, representing the future payments to be made under them, went heavily negative, as we know. Under the terms of the swaps, the banks required to be secured for the mark-to-market value of the swaps if they went negative. To meet this requirement, the society had to post cash collateral with the banks of the mark-to-market value at intervals. And we know from the judgment, I think I may not have shown you this yet, paragraph 111 at page 159, that in 2012, the claimant had put up £39.29 million of collateral with the banks. So my learned friend yesterday morning did slightly overstate her case when she said that the money paid to break the swaps was otherwise sitting unencumbered in MBS's bank accounts. Unencumbered was precisely what this money was not. It was being held by the banks as security. This was a very large payment which had to be financed, and that must have been very expensive. And I'll show you again some references to that in the 3 documents. We've also given some further references in our written case at page 76, footnote 8. The 5th reason why the value gap eventuated was that the society's income from the long-term mortgages was, as a result of the swaps, entirely and irrevocably locked into LIBOR. That was the whole point of the swaps, was to swap the fixed rate into LIBOR. When the society started this business, that seemed appropriate because the society's cost of funding, as indicated on my learned friend's diagram, both from retail deposits and the wholesale money markets, was also linked to LIBOR. That was the theory, and my learned friend has shown you her diagram that that's the theory. The problem is that in the financial crisis, as well as interest rates generally going down, the society's funding costs were disconnected from LIBOR and in the wrong direction. To some extent, I've shown you that already in the passage of the FSA letter at page 159, judgment paragraph 112, but I'll show it to you in the letter itself very shortly. But this was a significant factor. The society's margins were put completely out of kilter by the financial crisis because they had to pay much more than LIBOR for funding. And sixthly, there were also costs of administering the mortgages, of course, including provisions for defaults, which have no mirror receipts on the swap side. So those were the 6 real reasons. There may have been others, but those were certainly 6 of them that we can tell from the evidence that we have as to why the value gap opened up. The three documents I want to show you are all from early 2013. Well, the third one might be from late 2012, I'm not sure. But they all precede the discovery of the issue about hedge accounting. And they give an indication of the position just before that happened. So the first one is the FSA letter of the 16th of January 2013. It's at page 757 of the bundle. Now, I've shown you that the text of this letter is set out fairly extensively in the judgment at paragraph 112. Most of what I refer to is extracted by the judge, but a few sentences are not, which is why I'm inviting your attention to the letter itself. At 757, under overall assessment, the FSA said, the business model of the Manchester is one of the least sustainable in this sector, which sits rather ill with my learned friends' written submissions that they were particularly viable and sustainable. We then go to the next page, 758. It's a complaint at the very top, the risk management framework is inadequate. Under recovery and resolution planning, given our concerns around the sustainability of the society's current business model and the risks inherent in its capital and liquidity profile, it is important that you carefully consider the contingency option as available, including the option of merging with another society. So this is serious stuff. Under strategic planning, we understand that the current high-level strategy is focused on reducing risk-weighted assets and the level of basis risk to which the society is exposed. We agree this is appropriate, but we do not believe the current control framework will ensure it is delivered. And then the next paragraph, we view the society's funding profile as high risk and potentially unsustainable in the long term, and you must give detailed consideration to that. And then if we go, please, to 764, still in the letter, this is there's an appendix to, this is appendix 2 to the letter, risk mitigation program, and in the bottom right box, numbered 5, the regulator asks the society to produce a funding plan which addresses whether the society can maintain a sustainable funding profile. This should include a detailed breakdown of how the liquidity profile will develop over time with reference to funding costs, maturity profile, distribution channels, liquidity risk, and ILG requirements. And then at 765, Appendix 3, identified weaknesses in the risk management framework. And the first one that is identified is lifetime mortgages, interest rate risk, and foreign exchange market risk. And they say the ICAP, which is the society's own assessment of its risks, does not address the non-credit risks posed by the lifetime book in sufficient detail. The society holds a significant amount of lifetime mortgages and accompanying interest rate swaps on its balance sheet. While this business may have seemed benign in the mid-2000s, the falls in LIBOR and gilt rates have crystallized numerous adverse effects on the society's balance sheet, margin, and capital position. And that's absolutely right. And then they then refer to some of those risks. They then say under basis risk, the society operates a high basis risk profile due to a majority of assets being linked to bank base rate LIBOR, and a liability profile which is primarily driven by best buy retail savings rates. Now that's the point I was making about the disconnection of rates. What the regulator is saying there is that their assets, that's to say the mortgages, are linked to the bank base rate or LIBOR, but their liabilities, that's their deposits, are driven by best buy retail saving rates. So the only way they could get deposits was by matching best buy rates. And those two had become disconnected. And as the FSA says, the society's net basic risk mismatch is firmly in the top quartile of the sector. The society is exposed to the risk the net interest margin will deteriorate further due to adverse changes in the spread between asset and liability rates. So that was what the FSA was saying, including about the lifetime business at the beginning of 2013. And there was a response to that by the chief executive, Mr. Cowie, in a memo, which again was extracted in the judgment, as I showed you. But again, I'd like you just to, if I could, to show you the original at page 750. So Mr. Cowie told the board that the risk assessment letter provides a fundamental challenge to the society's board, first sentence on 750, going down to the next paragraph. The letter does not deliver any acknowledgement that the current position essentially relates to the impact from the credit crunch on the society's prior business model and the prevailing extreme financial market conditions. In particular, it does not recognise that bank base rate at 0.5% for nearly 4 years and the dislocation of the funding costs of the banking sector from the bank base rate. And that's absolutely right. So what had happened was the business model, which had seemed sensible, had become under enormous stress because of the financial crisis. The chief executive then goes on in the third paragraph, third line. The reality is the society continues to have a weak structural position. And he then explains in the fourth paragraph, improvements have been made. Nevertheless, the embedded position has meant that the society's risk profile has been particularly exposed over the last 2 years, and particularly 2011, to the reduction in bond yields, which had a material corresponding knock-on effect on swap rates, and in turn on the substantial value of longer-term derivatives held. So that is the chief executive acknowledging, before any issue about hedge accounting had arisen, that the society was exposed to the value of the derivatives it held, and that's the long-term swaps. So they knew they were exposed to that value. And tighter competition for funding in the UK brought on by withdrawal of the special liquidity scheme. So he knew that. And then if we go on to page 751, 2.2, he explains that the funding model prior to the credit crunch placed a greater reliance on wholesale funds. And those effectively, he goes on to explain, dried up, and they've now moved. So this changed fundamentally with the credit crunch as wholesale funding dried up. The need to replace this funding necessitated a greater proportion of retail funding met through an increase in postal accounts. And again, so this is about the fact that those were at much higher rates than LIBOR. And then on the next page, impact of the credit crunch on the society. The society's previous business strategy has been partly turned on its head by a complete change in the financial environment. The biggest impact on the society in financial terms is the dislocation between funding costs and bank base rate, which has substantially eroded the society's net margin. The average retail funding costs have remained at more than 1.5% over base rate at all times since the beginning of 2009. So that's over 2%. Peaking 12 months ago at nearly 2% over base rate. With over 80% of the loan book on a rate linked either to base rate or LIBOR, mainly fixed rates hedged through swaps, at the end of 2008, the society was able to pass on the funding cost dislocation to only a small portion of its loan book. So this is another big thing that went wrong, which wasn't the overhang. It was another thing that went wrong, was that the idea of matching the rates, the idea of my learned friend's diagram ceased to apply. And that's why it's a little bit surprising to us. My learned friend rightly said, we get all excited about this diagram, that this diagram is still put forward as what would have happened after 2013. It wouldn't. It had completely changed. There's then a reference just above heading 4, 2 paragraphs above that, last few lines of that, of the thirdly paragraph. The thirdly paragraph, the lifetime mortgage exposures are hedged using swaps. Swap rates have fallen materially. This in turn has resulted in a significant build-up of collateral deposits placed by the society as it's out of the money. This in turn generates an increase under IFRS in the book value of the underlying loan assets. The low gilt yields also increase the risk weightings of the underlying fixed rate mortgage assets to increase. The combined impact of both has been to dilute materially the society's tier 1 ratio. What does that mean? What that means, my lords, is that because while hedge accounting applies, that when your swaps go out of the money by 30 million, you've got to post 30 million of collateral, which becomes a risk asset on the balance sheet because it's still the society's asset in a sense. And that's a 30 million pound risk asset. But equally, because of hedge accounting, you put your mortgages up by 30 million on the balance sheet, and that's another risk asset. So your risk assets have increased by 60 million pounds as a result of the swaps going out of the money. And that causes difficulty with regulatory capital as well. So that's the point being made there. And we then go on to the next page, 753. The chief executive in the last paragraph bemoans the failure of the society to break a big chunk of the swaps, the BLB, that's Landesbank Bayerische. They've failed to take the decision to break the swaps. which ultimately led to a more heavily negative value at risk on the BLB swaps caused by this fall in swap rates. So again, they're well aware that they're exposed to the value of the swaps. And the top of the next page, 754, the chief executive says that Spanish lending could and should, with hindsight, have been curtailed earlier. So the business was not a good business. It should have been stopped earlier. And he explains that that would have all been done if the risk management framework had been more robust. And finally, the final paragraph of this at 756 is very important to what would have happened next. So paragraph 7.6, the board need to be aware there's unlikely to be a dramatic relaxation of the ICG scalar of 30%. So just that's the regulator imposed an additional capital requirement of 30% because of its concern about the risks, mainly of lifetime mortgages, for some time to come. Certainly while the society remains exposed to the scale of break cost risks on the long-term swaps. The main way to reduce the impact of the scalar in the next 2 years remains through the staged sale of UK lifetime loans and their replacement with other long-term fixed rate assets that have a lower capital consumption. Otherwise, we remain dependent on a recovery in swap rates, which will both reduce the capital requirement on the remaining loans and also capital tied up in IFRS value adjustments. So the background to the judge refusing to find that the claim that more profitable mortgages could be written was anything other than speculation was all this material that showed that the business had not just gone into runoff, but had caused disastrous problems before hedge accounting was undone. The third document is the one that my learned friends rely on, which is the business plan. Can I just show you what they say about it first? At page 42 of the bundle, paragraph 40 of their written case, footnote 22, they say, accordingly, the business model continued to be developed and maintained by the society. It remained an enterprise that it was ready, willing, and able to pursue into the long term. That is cogently illustrated by the business plan, 2012 to 15, which demonstrated the continued sustainability of the society's business model based on its belief it could apply hedge accounting and its intention to carry on with the venture. Now, all of that, of course, is completely opposed to what I've just shown you, and they say it's based on this business plan. And then the footnote says, see in particular, a line in the business plan, continued sustainability of the society's business model is demonstrated by the core plan forecasts and stress tests. Now, that all rather gives the impression, certainly gave me the impression, that they were saying that the business model referred to in that sentence of the business plan is the specific enterprise of lifetime mortgages matched with long-term swaps. Now, maybe your lordships didn't get that impression, but I did. But if so, that was unintentional, because if you read the document, as I'm about to invite you to look at anyway, that starts at page 647, it's clear that the business model referred to in that sentence is the entirety of the society's business. It's not the business model of the lifetime mortgages and the famous diagram. It's simply the whole of the society's business. So if we go to what the sentence that they rely on is at 690, and that relates to the whole of the, it's clearly the whole of the company's business. And then if we go through a few of the points that I want to raise from this document, if you look at page 679, in the middle of the page, the society's lending appetite for new lifetime lending was satisfied during 2009. No new lending is forecast. So this document that my learned friends rely on to demonstrate that it was ready, willing, and able to pursue this business model into the long term, in fact, confirms the point I've already made, that this business had gone into runoff in 2009 and was not going to continue. And as I've shown you, and this paragraph also confirms the point I've just shown you from the Chief Executive's memo, that they were looking for an opportunity to divest some of the UK lifetime loans, but the difficulty was going to be replacing them as against the swaps with some other long-term lending, and that was what they were finding very difficult. And the sense of the the sentence that's quoted, continued sustainability is demonstrated. When one looks at the whole document, and I can't ask you to read all that because it's too long, but I do submit that the sense of it is perfectly clear, that what they're saying is the society faces numerous problems, as per the documents I've just shown you, but it might be able to survive if it manages to reduce its balance sheet size sufficiently. That's what they mean by sustainable. They don't mean they've got a thriving business and a business model. They mean that they think they can survive. And I invite your attention also to page 657, which I think gives us some more of the figures on lending rates. Page 657, second paragraph up from the bottom, the underlying profitability. And you can just see in there, the last few lines of that paragraph, that the average cost of retail funding was between 2.07% and 2.3% in 2011. Whereas, of course, the base rate was 0.5 and LIBOR was less than that. And then in the next paragraph, margins were also adversely affected by a substantial rise in the collateral deposits placed with interest rate swap counterparties. The interest rates received from those deposits being at SONIA, which is, I have a note somewhere it's sterling in overnight interbank average. And SONIA, in fact, was only slightly more than zero, as you can see, because they say it's nearly 2% below the society's average cost of funds. So that £30 million worth of collateral had to be funded at a cost of 2%. At 660 in this document, there is more about the retail funding costs, which moved from 2.26 to 2.36 and peaked at 2.44. So again, you've got the funding costs. And the first paragraph under retail funding refers again to the dislocation between retail funding costs and the bank rate becoming more extreme, and that their organisation is primarily depending on retail funding. So this was a big problem for them, of which the society now has nothing to say about its impact. 680, there is the reference to provisions for defaults on the loans, which had to be accounted for, which doesn't have an analogy on the other side of the equation. And at 702, there's a strategy paper that was annexed to the business plan. And at 703, there's another problem referred to at 2.3.2, which is that the society was required to hold an increasing proportion of assets which yielded very low returns below even LIBOR. And then at 704, the paper explains, in the middle of page 704, the middle paragraph under 5.2 explains the difficulty the society is having in shrinking its book fast enough to comply. It's the middle paragraph. Middle paragraph is under 3.1. The main area where the society has difficulty is in its rate of progress towards full compliance with the main guidelines of the source book. The society is currently seeking to shrink the total monetary size of its loan book, so new lending levels are heavily restricted. At the same time, the rate of erosion of the book, that's repayment of mortgages and changes in mortgages, remains suppressed. So they're having difficulty shrinking the mortgage book fast enough to comply with what the regulator wants them to do. So, my lords, my lady, to summarise the facts at January 2013, the long-term mortgage, the lifetime mortgage business had been a disaster. It had been put into run-off in 2009. The society's intention was to try to sell it down as much as it could. The losses that had built up on those transactions were losses that were recognised by the company, by the board and the society as being losses to which it was exposed by having taken out the swaps. And they turned out to be unviable and unsustainable. Their commercial decision, based on the diagram that my learned friend relies on, had turned out to be a failure. The failure, which happened because of this financial crisis, turned out to be a catastrophe because of the overhedging, which made the losses far greater than they otherwise would have been. It's fair, of course, to say, and my learned friend does say, that the realization or crystallization of the catastrophe that had built up could no longer be postponed when hedge accounting error came to light. and the hedge accounting could not be applied. But that wasn't actually because that meant that there'd be volatility could go either way going forward. That was actually because by that stage, massive losses had built up. But the accumulated value gap was not caused by the hedge accounting error. And it's not attributable in any common sense sense even to the wrongness of Grant Thornton's advice on hedge accounting. My lords, my lady, I'm planning to move from the facts to the law. On the law, I propose to do the following. First, go through the key cases, pointing out the passages that I rely on as establishing and explaining what the principle of scope of duty actually is. Make a short submission that is now settled law. Make a submission about the burden of proof in the law. Say something about the audit is all different line of argument. I know my learned friend put it slightly more narrowly, but nevertheless to say something about why audit isn't a problem. And address the problem cases that have been advanced as showing that the principle can't always apply, in particular the dividend example and my Lord Burroughs' intellectual property example. And after that, I'll say something about legal causation and my contingent cross appeal on that. That's what I have planned. I've obviously at lunchtime work in somewhere the point about the wasted expenditure that my Lord Legate would like to hear me on. So, my Lord Burroughs.
Just before you proceed to that, if I may, you finished that section by, as I understand it, putting forward the submission that on any common sense view, the losses that the society suffered were not attributable to anything to do with the advice given by the defendants in relation to hedge accounting. I think that's how you finish off. Now, isn't that contradicted by the finding of Mr. Justice Tier that legal causation was satisfied in this case?
I disagree with that finding. I appealed it to the Court of Appeal, who didn't deal with it because it wasn't necessary, and we've raised it again in this House. We submit that he's wrong about that, and I'll make some brief submissions about that when I come to it. My Lord, even if I'm wrong about that, and if your Lordship, your Lordship takes the view the judge was right on the ordinary concept of legal causation, even then, it's still not attributable to the wrongness of the advice we gave or the information we provided in Lord Sumption's terminology. And that's why scope of duty would then matter in this case. Yeah. There are some cases where you get the same answer. We say this is one, and my learned friend says it's one, but that's because we both give a different answer to the two different questions. My Lord Hodge.
Yes. I was puzzled by the finding of the judge on legal causation, because if the Samco question is a prior question as to the scope of the duty of care and not a cutback on a basic loss, then one could not have, if Samco applies, a finding of effective legal causation.
Your Lordship is right, and that the loss below the amount which is excluded by the Samco counterfactual is not a loss within the scope of the duty. So in a sense, it doesn't matter whether it's caused or not caused by the negligence. So because it isn't a loss that's within the scope of the duty. So your Lordship is right that scope of duty is the first inquiry, and if it's not within it, then it becomes academic. Yeah. Whether it's caused, and that's the right way to look at it. And my Lord Legate.
Because what is clear from BP, and no doubt you're coming to it, is that Samco isn't about causation.
Yes.
Yes. Thank you.
That's certainly right. My Lord Legate.
Just a small point. It still wouldn't have been academic, would it? Because you wouldn't have been able to recover the break costs if you. Sorry, the claimant wouldn't if you'd succeeded on effective causation.
Oh no, my Lord, that's absolutely right. It's not entirely academic. It's only academic to the head of loss that remains in issue in this appeal. Your Lordship is absolutely right. If we won on legal causation, then we wouldn't have even had to pay the, well, if we won on legal causation, then we wouldn't have had to pay the break costs and so on as well. Yes, that's right.
But obviously, if you win on one defence or the claimant fails to succeed on one requirement, whichever way you put the Samco point, then to that extent, any other argument's irrelevant. So,
yes. Yes.
Thank you.
So, my lords, I'm going to run through. I think just the cases in this court and its predecessor. There's probably no need to turn up Caparo. It's in the bundle at 1069. But it is useful, I think, to remind ourselves what it did and did not decide before turning to Samco. So I'm proposing to narrate to your lordships what I say it decided. I don't think it's terribly controversial, but we can obviously look at the decision if we need to. The claimant Caparo had taken over Fidelity by buying all its shares on the stock exchange. Caparo claimed to have relied on Fidelity's audited accounts, which it said were negligently misstated. And there were two preliminary issues argued. They were both argued as points of law. The first was, did the auditors owe a duty of care to any person who might buy shares in the company in reliance on the audit report on the basis that a takeover or buying of shares was reasonably foreseeable? And that first question was decided in the negative at every level of decision in Caparo. It was a pure duty to whom question of a fairly familiar sort now. The second question was the difficult one, which divided the Court of Appeal, which was whether the auditors owed a duty of care to a shareholder who relied on the accounts to buy more shares, because Caparo at one point was a shareholder and then there was a set of accounts and then he bought more shares. And in relation to that question, it's important to remember that it was the claimant who relied on the statutory background to auditing in order to demonstrate that auditors did owe a duty of care to shareholders at all, rather than just the obvious contractual duty to the company. That was the context in which the House of Lords gave detailed consideration to the statutory background and purpose of the audit, and concluded that while the auditor did owe a duty of care to shareholders, it only owed that duty of care to shareholders as a body in their capacity as an organ of the company and for the purpose of stewardship of the company. And it was not owed to them in their capacity as potential investors. And that's the decision in the case. Now, that was not a decision, that was a decision based on limiting the types of reliance in relation to which the duty was owed. So the first issue decided was simply duty to whom. The second issue went a step further because it wasn't just a duty to which person, but it was a duty for what types of reliance. Now, that's my terminology. The terminology in Caparo was in part taken from Lord Justice Denning's dissent in Candler and Crane Christmas, where he said, when would we expect to find a duty owed? And he said, for the very person and for the very transaction for the purpose of which the advice was given. So the phrase used there was the very transaction. And that's very clear in the decisive passage of the speech of Lord Bridge at the end of his speech, and also Lord Oliver at 1118. So that was the context in which both counsel, as recorded in the report of argument, and the court in Caparo used the term scope of duty. They used it in that context of the very transaction, or as I would put it slightly more broadly, the type of reliance for which purpose the advice was given. And that was all that was needed to decide Caparo. Caparo was not a case with a single head of loss that needed to be divided between parts that were attributable to one kind of one fault or another fault, or matters that were no fault at all, divided between risks. It was a case where the type of reliance alleged was not within the type of reliance for which the defendant had made the impugned statement. So the whole loss fell outside the very transaction. So that was what was decided in Caparo in my submission. Then we come to Samco, which we have in the bundle at 1289. Obviously that's familiar, and obviously, equally obviously, the whole judgment is relevant if your lordships are going to look at the Samco principle in detail. We can see the principle stated clearly at 1311 in the report at 213C to D, normally the law limits liability to those consequences which are attributable to that which made the act wrongful. And of course, that's being distinguished from consequences that flow from the act. It's to that which made the act wrongful. In the case of liability for negligence for providing inaccurate information, this would mean liability for the consequence of the information being inaccurate. And then at 214D, a duty of care which imposes upon the informant responsibility for losses which would have occurred, even if the information which he gave had been correct, is not, in my view, fair and reasonable between the parties. So that is a clear statement of the principle about what is and is not within a duty of care. And then, of course, letter E, Lord Hoffman set out the distinction between advice and information. It may have been better if, I don't know whether it was him or the reporter who put the emphasis on the words provide information and advice, which, of course, as everyone has recognised later, that isn't the real, those words themselves do not contain the distinction being drawn, but the distinction is nevertheless drawn clearly there between advising a claimant on what course of action to take and providing some information that goes into the course of action. And your lordship saw yesterday, I think with my learned friend at page 1313, that where Lord Hoffman explained that Bank Kaiser, Ullman and Scandia was an example of the principle, while acknowledging that Lord Templeman put it in terms of causation. Now, my lords, I want to go back to one point in the argument at page 1304 to draw attention to the fact that, and this is the argument of Mr. Roger Toulson, Queen's Counsel, as he then was, for one of the banks, United Bank of Kuwait. And at the foot of 1304, we see that he is attacking the idea of a cap and gives some objections in principle. And then at the very foot of 1304, he says, therefore, if damages for breach of contract and advising carelessly, because remember, obviously, Samco was a contract case, were to be subject to a cap equivalent to the damages that would have been recoverable if the valuer had warranted the correctness of his report, but had not been any under duty to advise carefully, a question of burden of proof would arise. Would it be for the plaintiff to prove what his damages would have been on the basis on which he's not claiming, or would it be for the defendant to establish the cap? The plaintiff does not need to establish the figure to prove his loss resulting from the breach of duty, and accordance, the burden should not be on him. Either way, it would require the court to conduct a hypothetical inquiry not directly relevant to the basis of the claim. So Mr. Toulson raised the point about burden of proof as part of his argument against the cap. And against that background, it cannot have been just accident or coincidence that Lord Hoffman twice expressed himself in terms that made it clear the claimant had the burden. We see that in our bundle at page 1316, at 218B to C. A plaintiff has to prove both that he's suffered loss and that the loss fell within the scope of the duty. And again, at 2 pages on, 1318 in the bundle, 220A to B in the report, the appearance of a cap is actually the result of the plaintiff having to satisfy two requirements. First, to prove he suffered loss. Secondly, to establish that the loss fell within the scope of the duty. My lords, my lady, I pass to NICredit number 2 in the bundle at 2017. The issue, of course, here was when interest started to run, which is why the basic loss mattered to that inquiry rather than the counterfactual loss. If we go to page 2021, Lord Nichols explains the principle very clearly on report page 1631, letters D to H. And he sets out the distinction between two amounts. The basic measure of loss, which is the comparison between the claimant's position if the defendant had fulfilled his duty of care and the claimant's actual position. And secondly, the adverse consequences of the transaction, which are attributable to the deficiency in the valuation. And Lord Nichols says that G, For reasons spelled out by my learned friend Lord Hoffman, the defendant valuer is not liable for all the consequences which flow from entering into the transaction. He's not even liable for all the foreseeable consequences. He is not liable for the consequences which would have arisen even if the advice had been correct. He's not liable for these because they are the consequences of the risk the lender would have taken upon himself if the valuation advice had been sound. That's a clear statement of exactly what the principle is, and it's one that is determinative of our case. For what is the valuer liable? The valuer is liable for the adverse consequences flowing from entry into the transaction, which are attributable to the deficiency in the valuation. The principle was, my Lord Burrows.
Just before we leave that passage, that strikes me as a very important explanation as to what is underlying Samco. I mean, it is correct, is it not, that what is being said here is it's a risk allocation device. One is ultimately trying to decide who should bear the risk of these sorts of losses, and that the Samco formula or tool is a guide to working that out that may or may not be applicable in all cases. Do you think that's a fair analysis?
With respect, my lord, I submit that it's not. We'll see some other authorities later which confirm this, but the way Lord Nichols puts it at G is he is not liable for the consequences which would have arisen if the advice had been correct. That's the counterfactual inquiry. And then he says he's not liable for these because they're the consequences of the risk the lender would have taken. So the justification for the counterfactual inquiry is that it divides out the risks. But that does not mean that the principle that the law has developed is the principle that the first instance judge simply has a go at working out which risks are attributable. But instead, the principle is that the tool is to be used.
Are there any exceptions to that on your submission?
No, my lord. Where it's engaged, and I'm going to, when I get to Hughes Holland, I'm going to say the particular circumstance where it's engaged is the first sentence of Lord Sumption's judgment in Hughes Holland. And
so you're not going to accept that there's any counter examples that produce what appears to be intuitively unhappy results. You said there's no exceptions.
No, that's right, my lord. That's what I say. I mean, I don't say somebody. I know that nobody will ever come up with a counter example. But I don't accept that any of the counterexamples that have been adduced so far are counterexamples, and I'll deal with them specifically.
Thank you.
The principle is also summarised again by Lord Hoffman at 2028 of the bundle. Again, in clear terms, at 1638, just above letter F. In order to establish a cause of action in negligence, he must show that his loss is attributable to the overvaluation. That is, that he's worse off than he would have been had it been correct. And he then goes on to say there that it's important to emphasise this is a consequence of the limited way in which the House defined the value as duty of care and has nothing to do with questions of causation or any limit or cap. So he there repudiates the idea that it is a question of causation, and he also confirms the burden of proof in the passage I just read from just above F, but he also makes it clear where he thinks the burden of proof lies at D, to prove that the lender is worse off, and at H again, I'm sorry, I can't find the reference to H, but he certainly confirms the burden of proof at D and F. That's what I wanted to say about NI credit number 2. We then go to...
Can I raise a matter with you just before we go on to the next case, just while it's in my mind? I mean, one of the peculiarities about this case, it strikes me, is that contrary to what has been repeatedly said during the course of the hearing, it's a case where the bulk of the swaps had been purchased before the advice was given.
I'm not sure if I can say the bulk.
They weren't purchased in reliance on the advice. And the strategy of the commercial strategy of using them to hedge the risk on the lifetime mortgages was also something that had been decided on before the advice was given. Now, the advice was negligent. One could have said that if a correct advice had been given, then the building society would have terminated the swap contract earlier than it did, and would have avoided the loss that subsequently arose on the termination of the contract. And you might have assessed damages on that basis, but that's not the way the case has been approached. As I understand it, the way the case is approached is to say that a loss arose because when the when the error in the advice was discovered, the swap contracts then had to be terminated at a time when the claimant was out of the money on them, whereas the claimant would otherwise have been able to wait for a recovery in long-term swap rates and avoid incurring such a loss. I think that's how, it's probably for a day and a half what the loss was, but I think that's how it's put, if I'm understanding the argument. And it's inherent in if that's the argument, then I don't think one necessarily has to rely on Samco particularly to say that if that's the argument, then it's necessary for the claimant to show that there would indeed have been a recovery in the long-term swap rates if which the claimant could have benefited from if the contracts hadn't had to be terminated when they were.
I think what Ms. Savinclair would say was that the basic loss, the sort of but-for chain of causation, and indeed on the judge's findings, the legal causation as well, was that if Grant Thornton had given correct advice, then the small number of swaps they'd already bought would have been closed out, and they wouldn't have bought any more. So they never would have.
When you say small number, I thought that was 3 £20 million contracts.
Your Lordship may, I'm not sure about that. There were certainly 3. No, the 20 million is a reference to the size of the UK book. That was the 21 million books. Your Lordship may be right. The nominal may have been as much as 21 million. I don't remember. But it wasn't the bulk, I think, of what was left.
Okay.
I don't think I can say it was the bulk, but Your Lordship may be right. I'm looking around the answer, but in any event, that perhaps doesn't matter. But but I think that what the claimant would say is that its basic loss was that it would have not had the swaps in 2013 at all, and that it's only in the Samco counterfactual world that one has to ask the question, well, would those losses have been suffered in any event? So if it was just, if all we had was but-for causation, then on the judge's findings, we would be liable for whatever they lost on the swaps, if all we had was but-for causation. So that's their basic loss. So I don't think I can quite seize Your Lordship's point sort of with both hands.
I see. Right, so you think the loss is the result of buying, effectively entering into the contracts and then they're being terminated at a cost to the building society?
Well, as I mentioned yesterday, one of the difficulties is that the claimant's case actually seesaws between 2 quite different positions. But one is that position, which, as I've suggested, is their real case, that in reality, they made a big net loss on this business and it had to be closed out. And then the other way they put it is to say, no, the business was fine, but we made a loss because we had to close early. And the reason that they put it in that second way is because that's the only way that they could arguably get through Samco.
I see.
But the reality The reality is quite clear. The real loss was caused by entering into this business. And my submission, that really is quite clear. That's what the loss was caused by. And that's why one needs a filter. And if it's not legal causation, then it has to be scope of duty, because otherwise it is the contribution of Grant Thornton to that loss is minimal.
Yeah. So you're saying that one way of looking at it is that what happened after, or what might have happened after 2013 simply doesn't enter into the picture. The basis of the claim is entering into these contracts or at least some of them, in reliance on the negligent advice and the contracts, and then incurring a cost when the contracts were terminated. And then the Samco issue arises because the information provided by the auditors was only a part of only one of the factors that entered into the decision whether or not to enter into these contracts.
Yes.
And then the alternative approach is to say that actually the loss arises from the necessity through the discovery of the negligence, the necessity to terminate the contracts while they were out of the money, whereas if matters had run their course, there might well have been a recovery in long-term swap rates.
Yes, and that second way,
there are two completely different ways of approaching what the loss is in this case, and how it arises.
That's right, my lord. And the second way of putting it seemed to come very much to prominence in the written case of the appellants. But as I understood my learned friend, although she was still pursuing the case, which is why I've answered it, she perhaps realistically sees that the first way of putting it is much more realistic on the facts of this case, which does mean that there was a loss. But the question is whether Grant Thornton is responsible for that loss. Whereas the first way of putting it actually leaves them with no additional loss at all, other than what Grant Thornton has already paid for.
Yes, and you would say the second way of putting it fails, amongst other reasons. It fails because they can't discharge the burden of showing that there would, on the balance of probabilities, have been a recovery in long-term swap rate.
Yes.
But obviously that issue doesn't arise in relation to the first way of approaching the loss.
No, it may arise on when you then get to Samco. But I mean, we also say that the simpler way fails because it simply isn't. There just isn't a loss involved in buying out contractual obligations at their fair value. That's not a loss.
Yeah.
So, my lords, I was going to turn next to Platform Homes at page 2045 of the bundle. In Platform Homes, the valuation at 1.5 million was negligent. It should have been 1 million. The basic loss of the lender was 611,748. The complication was that the lender was also contributory negligent for imprudent lending, and that contributed 20%. So the question was whether to award 80% of the 611,000, which was less than which came to 489, which was less than the overvaluation of 500,000, which was the judge's approach, or whether to award 80% of 500,000, the overvaluation, which is 400,000, which the Court of Appeal preferred. One imagines there may have been other cases turning on this point, since it reached their lordships, who restored the order of the judge. And the decision in that case is that the interaction with contributory fault is not particularly key for us, but it's a very useful case in terms of explaining what the principle is, because their lordships have to grapple with a difficulty that had arisen in interpreting it. So at 2055 in our bundle, page 200 of the report, Lord Hobhouse quotes Lord Nichols from NICredit number 2 and says at 2056 at 201G of the report that the first step is to establish the basic loss. The second is to see if it exceeds the amount of the overvaluation. And then going on to 2060 at 205 E to F of the report, Lord Hobhouse notices an argument that was dealt with in the Court of Appeal. The plaintiffs contended that the loss could be subdivided so that one part of it would be entirely attributable to the defendant's negligence, and there'd be no need for a deduction by reference to scope of duty or contributory fault. And as Lord Hobhouse records in that paragraph, the trouble with this is that in both Samco and NICredit number 2, the House decided that the whole loss was caused by the defendant's fault. So you had an indivisible loss, and that was the analysis which the unanimous House of Lords decided in those two previous cases. Lord Hobhouse then explains that further on the next page. So report pages 206 on to 207. And he essentially explains, starting at 206F in our bundle at 2061, that in the Samco litigation at the start, Mr. Justice Phillips had attempted to subdivide the losses as a matter of causative attribution. That phrase is at letter G on page 206. And as Lord Hobhouse then explains at 207C, our bundle page 2062, the approach of Mr. Justice Phillips was not resurrected in the House of Lords, and it certainly received no support from Lord Hoffman. And Lord Hobhouse then goes on to emphasise that it was made clear in the earlier decisions that the principle has nothing to do with causation. Makes that clear at F and again at G in those paragraphs. And he makes this important statement then at G, that the Bank-Bruxelles principle is essentially a legal rule which is applied in a robust way without the need for fine-tuning or a detailed investigation of causation. And Lord Hobhouse then addressed the relationship between the various concepts, causation, remoteness, and scope of duty, directly at our page 2063, report page 208D to F, goes through the way it works and the relationship between causation and attribution in the scope of duty sense. At 2064, page 209G of the report, Lord Hobhouse, after citing Caparo, says the development of the Caparo reasoning in Samco was that Lord Hoffman, instead of applying it to categories of damage, applied it to the quantification of damage. And that's exactly right, if I say so with great respect. That's right. There was a significant development. Scope of duty was then understood not just in terms of damage arising from particular kinds of reliance, but to the quantification of an indivisible head of damage. We then go on to Lord Millett, the other main speech in Platform Hose, at 2068 of our bundle, 213 and F to G of the report. Lord Millett makes the point about causation perhaps even more clearly. Necessary to recapitulate what this House has laid down in relation to the assessment of damages in cases of the present kind. Two calculations are required. The first is the calculation of loss incurred by the lender as a result of having entered into the transaction. This is an exercise in causation. The main component in the calculation is the difference between the amount of the loan and the amount realised. The second calculation has nothing to do with questions of causation. See NICredit, Lord Hoffman. It's designed to ascertain the maximum amount of loss capable of falling within the valuer's duty of care. And then Lord Millett makes another very important point, which I think is not made elsewhere, where he, in the last paragraph on that page, he says, it is to be observed that neither amount is an element or component of the other. Either may be greater, for they are results of completely different calculations. In mathematical terms, they bear the same relationship to each other as A minus B does to C minus D. The figure produced by the second calculation is simply the amount of the overvaluation. It's not the loss or any part of it, and cannot be equated with the loss sustained by the lender in consequence of the overvaluation. And that point is one that's worth bearing in mind when one comes to the problem cases. that the two things are not actually necessarily components of the same commercial or monetary entity. And that's important to the decision on the contributory fault issue in the case, as we see on the next page, 2069 at 214 B to C, that if the premise were correct, that the 500,000 overvaluation represented any or all a part of the damage suffered by the appellant, the conclusion would follow. But as I pointed out, that's not correct. The 500,000 is merely the amount of the overvaluation. The damage which the appellant suffered is not the 500,000, but the 611,000 basic loss. That's the damage referred to in section 1.1. So that understanding of the difference between the two amounts is actually important in the decision of this case. And I'll come back to that when we come to the dividends. My lords, Anaco, we have at 969, but the House of Lords starts at 992 in our bundle. And as your lordships probably know, but I'll certainly show you in a moment, this court in Hughes Holland stated that the decision in Anaco is not authority for any general proposition of law beyond the particular factual context of that case, though it has adopted Lord Millet's summary of the law from his dissenting speech in Anaco as being correct. Extrajudicially, my Lord Burrows has gone further and stated that in applying Samco, Lord Millet's dissent was correct. We've got that in the bundle at 1337. In Anaco, we see at paragraph 7 in the speech of Lord Slynn that there was no dispute as to the law. And going on to, sorry, it's Lord Lloyd, I'm so sorry, we're on to Lord Lloyd at that point, no dispute as to the law. Going on to page 994, still in the speech of Lord Lloyd, paragraph 17, he held that on the facts, the brokers were advising Anaco as to what course to take. So this was an advice case on the facts as he analysed it. Lord Steyne, the other leading judgment in the majority, began his judgment at paragraph 20 with the central issue in this case is not one of high legal principle, but an evaluative one involving matters of fact and degree. This would not have been fully apparent when the appeal committee granted leave to appeal. The last sentence of the same paragraph sets out the question whether the case is an information case or whether the brokers are undertaken or assumed a duty to advise the company as to what course of action to take. And then at 997, paragraph 36, Lord Steyne states that the case can be decided by applying settled principles. And he then goes on to set out what he calls the contours of established doctrine. So already in 2001, the Samco principle was settled and it was established doctrine. The end of paragraph 37, Lord Steyne points out, this is on the right-hand column of the same page, that the House has twice followed and applied the law as stated in Samco and refers to NI Credit number 2 and Platform Homes. And at 998, the next page, paragraph 40, Lord Steyne says in the middle of that, that's 8 lines down in that paragraph, on the left-hand side, the issue is simply, did the brokers undertake a duty to advise Anaco as to what course of action they should undertake? So a classic statement of an advice case. And on the next page, 42 to 43, Lord Steyne concludes that the brokers did assume such a duty. And he reiterates that this was really an appeal on the facts for which the brokers were fortunate to have obtained leave. It's notable that the majority judgments in Anaco say almost nothing about the law, beyond plainly accepting that the Samco principle is by then well established. Like the majority, Lord Millet, dissenting, recognised that the appeal itself was on the facts rather than the law. That's page 999 of our bundle at the end of paragraph 45. And going on to page 1000, paragraph 54, Lord Millet says something which is perhaps relevant to the underlying policy question here. About 6 lines down in paragraph 54, he says, in traditional cases of negligent conduct which causes physical injury, it's seldom been found necessary to place limits on the scope of the duty of care or the extent of the defendant's liability for foreseeable consequences of his acts. Claims for damages for economic loss, which is a result of a negligent statement or advice, however, are very different. There's a potential for foreseeable but indeterminate and possibly ruinous loss by a large and indeterminate class of plaintiffs. Foreseeability of reliance alone is not a sufficient limiting factor. And there's not, as I think my Lord Burrows has pointed out extrajudicially, there's very little said about policy in any of the leading cases. But here is one statement, and if I might, I'll just inject, if I dare to do so, one further reason in support of what's said here by Lord Millett, which is that the other point is that where you are dealing with negligent misstatement leading to economic loss, there will also be any number of risks involved, some of which may be taken on voluntarily, which is quite different to physical loss, where the defendant is, generally speaking, not choosing to take the risk, but simply exposed to physical damage caused by the defendant. Sorry, I may have said defendant when I meant claimant. My Lord Burrows.
Can I just at this point, I think you may have finished on Anaco, but I just want to take you back to an issue that was raised by the Lord President about where you start with this whole inquiry. So a conventional view might be said to be that when one is assessing damages, the starting point is that you are aiming to put the claimant into as good a position as if no wrong had been committed. A case like Livingston and Royard's, Coal Company, or Robinson and Harman. Is there not a difficulty with applying that principle, which is really one of factually caused loss, if you start by saying you first have to decide the scope of the duty? I'm not necessarily wanting an answer to that now, but there is an authority that I would be interested in your views on, because it raises this precise question, called Grange and Quinn, 2013 EWCA 24, Lord Justice Jackson, looking specifically whether Samco has changed the starting point from being Livingston and Royard's Coal Company and rejecting the view that it has. And of course, we have many subsequent decisions, including of this House, where the courts have said the starting point is always the Livingston and Royard's Coal Company, cases like Morris Garner and One Step. So I would be interested in that submission, because one can see that if you start with scope of duty, the burden of proof would most obviously be on the claimant. If you don't start there, then I would suggest, as a matter of principle, the burden is most obviously on the defendant.
Well, Michael, can I venture an answer to that? As we know, in Samco itself, Lord Hoffman said that the Royard's principle was the wrong place to begin in that case. The Royard's principle, if I can call it that very roughly, is the starting point in a case where you don't have a scope of duty issue because you don't have an indivisible head of loss. So it is the traditional starting point, and it remains in the Samco world the starting point for calculating the basic loss, as it's now been called, and as I've shown you for example, in platform homes. So it remains the starting point for calculating that figure, but it's not the starting point for liability, because the starting point for liability is always the duty. Which one you start with in my submission is not the key question that will determine the outcome of cases. Both of them are matters that the claimant has to prove, and that has been clearly stated now several times. They're both matters that the claimant has to prove. It may seem an oddity that the tool which has been developed in order to elucidate what the true scope of duty is a tool that involves a counterfactual, where it could be said that it's not totally clear who should have the burden on the counterfactual. But the position that has been reached, and is absolutely clear law now, is that that is part of proving what was within the scope of the duty, and therefore what was the nature of the duty. Using that phrase, scope of duty, in its broad sense, as it was used in Caparo, but then as expanded in Samco. And while that could be a question, it's a question that's been decided. But my lord, obviously, I haven't looked at Grange and Quinn, but I do say that the starting point is not going to be decisive. It's not the starting point that matters. What matters is that you make both inquiries where both inquiries are needed.
Thank you very much.
Well, I wonder, Mr. Salcedo, if that might be a convenient point to adjourn.
My lord, it's certainly a convenient time by the clock. I've got some more on Anaco, but my lord, I'm very happy to take the break.
Very well then. We'll resume at 2 o'clock.